Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I'm coming to you from my office in Brooklyn, New York, and I wanted to talk about a recent settlement that was really groundbreaking, an amazing settlement. It wasn't in New York, it was actually in the state of South Carolina, and it was really amazing because the initial demand or request for money in the case by the plaintiff's attorney, that's the attorney representing the injured party, was $800,000. So usually if you're asking for $800,000, you're expecting to settle the case for maybe $500,000, maybe $300,000, maybe even $100-something thousand or less than that. But in this case, the end result was much, much higher than $800,000. So I want to explain to you how they did it and how they achieved a multi-million-dollar result on what was an initial demand of only $800,000. And it's a very interesting case, and I think it has a lot of lessons that lawyers could apply and clients could apply perhaps all over the country. And it's really a blueprint for how to handle a case properly and how to negotiate a settlement and how to achieve the best possible settlement that you can achieve as an attorney and as a client, right? As an injury victim. So let's get into it. So the case involved a young boy, and him and his family were staying at a resort in Myrtle Beach, South Carolina. And unfortunately, he had really bad burns, chemical burns, due to the chlorine in one of the pools. Now, this was a large resort. I believe they had 11 different pools. And so initially, the lawsuit or the investigation involved finding out why was he burned? Why did these chemical burns occur? And the lawyers thought that it was because of the high chlorine levels in the pools. So they filed a lawsuit and they began investigating this resort and this pool. And they were given these documents, and the documents just said, look, all the pool levels are exactly fine. Everything is normal. They're being checked every day. And it was almost like too good to be true. And the clients were actually from, I believe they were from North Carolina. They were from a small town. And they were the type of people that say, well, you know what? Even though this boy was really badly burned, he was so badly burned that his skin was peeling off and he had permanent scars, and people had to go in and fix the dressing and take care of the scars. And when they did that, even the grown men would just get sick because it was just so horrible to look at. But despite all that, if you asked his mother, how are you doing? She would say, we're doing great. Because these were the type of people where they just say, look, things happen and life goes on, and we just have to learn how to deal with it. So they were kind of like a stoic family. So despite this, so the point was that with these records, it was just too perfect. So they thought, hey, maybe they're falsifying these records. And so initially, they had sent a letter for an $800,000 demand because there was a recent verdict in the same state for similar injuries, and that verdict was for $815,000. So they put that in the demand letter and they sent it out. And this was in 2021, and there was no response. So the letter was a settlement opportunity letter where they said, look, you have to pay us within 30 days. Here's the deadline. If you don't pay us, then this opportunity is gone, and then the amount is going to be higher. So the insurance company didn't pay. And at that point, they didn't even know, the plaintiff's lawyers did not even know how much the policy limits were. I think they were told it was only $1 million. So after this all, expired, the demand expired, the opportunity expired, they basically planned to litigate the case. And when they questioned this particular safety manager who was in charge of this pool, who was doing the testing, he admitted that he was falsifying these records, that it was not true, these chlorine levels. So and they had it tested, and the chlorine levels were much, much higher, and that's why the boy was burned. So it was, in a sense, it was really strong discovery and really a good investigation, and they found almost like smoking gun type evidence. So this was very good. And so when then at that point, the insurance company said that we have a bigger policy. We have up to 11 million in insurance. So then the opportunity changed and they said, okay, we're going to ask for 11 million and that's going to be open for only 30 days. And if you don't pay it, that's going to go up. So then at that point, they had a plan that they weren't just going to say, hey, pay us 11 million, but they were going to do something every week while that 30 days is open to really kind of play with the defendants, not play with them, but like to push them to pay and push the insurance companies to pay and show them that we really mean business. And one of the things the plaintiff's attorney did was they asked, well, have you now terminated this particular individual? I think his name was like Mr. Rivera, the individual who was falsifying these records. And then actually it was when the defense attorneys received that demand, that request for a discovery from the plaintiffs, only at that point did they actually go ahead and terminate this individual. So they were going to let him continue working. And so the plaintiff was going to use that, as part of their case. So they just kind of went on the offensive in discovery. They looked at the statutes. They got the Department of Health involved and all the Department of the Environmental Conservation, everybody who was in charge. And at that point, when the 11 million, 30 days for the 11 million expired, only at that point did the defendants finally make an offer, and their initial offer was only $400,000. So the plaintiff didn't, think, we have to lower our demand. No, they actually did the opposite. They kept going up, and they kept strong. And at that point, this particular individual, Mr. Rivera, the safety person, he was actually arrested because the police and everybody and the Department of Environmental Protection, what they did was they found these safety violations, and the plaintiff hired their own expert to go into this resort and to check all the pools, and they found like just dozens and dozens of safety violations everywhere, to the point where it was wildly unsafe. And at that point, the state Department of Environmental, the government entity that controls all of this, they shut down the entire resort and they shut down all 11 pools. And then the plaintiff did more depositions. So now they were deposing another supervisor, and they asked this supervisor, well, would you like to know how many times this pool safety person you have, this employee, Mr. Rivera, how many times he falsified the pool chemical logs? And this supervisor, who was his boss, said, no, I don't really care. You see, and at that point, they started showing that, hey, these guys, not only are they letting these dangerous employees in their business, but now they don't even care. So, and then they kept deposing supervisors, and the next supervisor would say, he just plead the fifth. He would say, I plead the fifth, because they realized, hey, this could be criminal, that you're knowingly falsifying logs, and you have these high levels that are burning people, and this is criminal conduct. So they pled the fifth, which is, the right against self-incrimination. And I believe the main supervisor pled the Fifth Amendment in his deposition 21 times. And in that particular state, in South Carolina, if you do plead the fifth, that's a negative inference that your testimony would have been bad, obviously, right? So then they used that in the state case. And then the other thing the plaintiff's attorneys did was they went on a really good investigation, and they scoured the internet, they scoured all these travel websites, and they found other people that were injured, other people that were burned in these review websites. And so one of the people that was burned, and I believe his family was burned also, he actually agreed to be a witness for the plaintiff. And then at that point, another lawyer for the plaintiff questioned the corporate representative. That's under section 30B6, where the company you're suing has to produce a person who's going to speak on behalf of the company, becomes the voice of the company. And they asked that witness, well, do you know this particular individual, this other person? And she said, no, I never heard of him. He doesn't even exist. But then this particular individual said, look, that's the person I complained to. It was the same 30B6 witness who the defendant was putting up as the voice of their company. So that was really powerful impeachment, that this company is lying. And at that point, the defendants finally offered $1 million. And they made it seem like they were offering all the money in the world. They said, oh, we're offering you $1 million. and then the plaintiff's attorneys at that point said, look, now we have punitive damages against you because this is willful, wanton, gross negligence. You knew that these chemicals in this pool, this chlorine level, was way unsafe. It's not just a little bit above. I don't know if it was double or triple, but it was way above the normal limits. And you falsified the logs, and you knew that this was likely to cause harm to people. This is a resort. People are kids. Everybody's using these pools, 11 different pools, and people are being burned. This person was burned, chemical burns for life, and you just don't care. And so this was punitive damage. So they said, no, that's off the table. We're not accepting $1 million anymore. And at that point, now remember, the defendants kept saying that they only had $1 million. And then later they said, no, we have 11 million. But the plaintiff kept pressing. They kept saying, look, give us all your excess, your umbrella, your supplemental. Are there any other coverages? Where did you apply for insurance? Tell me the broker. I want to speak to them. And then I want to see any other policies, because sometimes another policy will reference the first policy or vice versa. So they really did a deep dive, and they found out that this particular resort actually had a total of 26 million in insurance. So at that point, they were just preparing the case for trial. And what the defendant tried to do now, and you see all these tricks that the defendants try to do, was they tried to delay, and they tried to say, look, keep your 11 million demand open until the mediation. Just keep that open. They tried to string everything out and ask for adjournments. First, they said, oh, the primary insurance policy, the primary insurance carrier, they need an adjournment. Then when they said, okay, we'll give you a little bit of an adjournment, like 2 weeks, oh, now the excess carrier needs an adjournment. And they kept pointing the finger at each other. But the plaintiff's attorney said, no, we're not going to keep the demand open until mediation. That 11 million is gone. Now it's all of your insurance that's available, 26 million. And even that is not going to be kept open, because if we go before a jury, we're going to ask a jury for 50 million. This is a big case. This is, punitive damages. You have, this is a big, and plus the person was really injured. And at that point, they did like a day in the life type video, or they did a video that explained the injury to the boy. And they were on the trial calendar, and they were about to go to trial when at that point, it was the expiration now, the 30th day at 5 p.m., the expiration. It was actually in January of 2024 when the 26 million, all the available insurance would, and that letter was going to expire. And at that point, they were going to go to trial, and they were going to ask for, I don't know, 50 or maybe even 100 million. But on that day, right before, I think an hour before the expiration, the insurance companies called and they said, okay, we agree, 26 million. So the case settled for 26 million. So I thought it was a really good job. So he's just sticking to your guns, believing in your case, not letting the insurance company boss you around, calling the shots, saying that this is what it's worth. If you don't pay me, fine. And just preparing the case. And not just like asking for a number and doing nothing, right? But asking for a number, like saying first it was 800,000. Okay, no. Okay, then it was like 11 million. But see, when you make that demand for 11 million, having a plan in place that while those 30 days of that opportunity are open, you're going to do something. You're going to depose these people. You're going to show what kind of criminals they are, what kind of crooks they are, that they're lying, that they're falsifying. You're going to prove punitives. And so this was a team effort. This was actually an attorney in South Carolina who I know. He's an excellent attorney. And another group that is our national trial lawyers that have received many multi-million-dollar verdicts all over the country, and they teamed up and they did an amazing job. So kudos to them, big congrats. But let us know what questions you have, and we are here for you. If you have a question, you feel free to leave it in the comments, and we'll be happy to either answer it in one of our Last Week Tonight episodes, or we can answer it live in one of our lives. And also, if you have a specific need for a consultation, you could always text me 347-566-9595, and I'm happy to jump on a call or text you back and chat and see if I could help. Whether it's in New York, I could help you myself, or if it's somewhere else, we partner with some of the best lawyers all over the country, including these lawyers. We've worked with them in South Carolina and in other states. They're all over the country, like I said, and they've received some of the really amazing verdicts. One of the verdicts recently was actually a toxic tort for, I think, almost over $850 million, and they've gotten many verdicts for 40 million, 20 million, just incredible verdicts. I think they had another toxic tort earlier for about 250 million. So just amazing verdicts, and they're really, really good trial lawyers. Okay, all the best. Please like and subscribe to our channel. Let us know what questions you have, and we are here for you. Our goal is helping serious injury victims and families. Okay.